Hello and welcome to the King Heroes Journey podcast. My name is Beth Martins, and I'm super happy to be here with this panel that are going to talk about the Canadian Federal Court ruling against its own executive government. So we have Jane Scharf, yeah, Jane's doing the happy dance,
Yeah.
and Patti, can you say your last name?
Mcintomney.
Mcintomney, thank you. Janice Currey, who I had the pleasure of meeting here in Manitoba, who's been a strong force, and Norman Traversy as well. So we're going to be discussing the ruling itself, what implications it has, specifically because it was a charter win. I'm very curious about that. Give me a minute. I'm just having a little notice that they're having trouble streaming to Rumble. And so we might have to upload to Rumble after. I'm not sure I could do anything about that right now. I'm brand new to Rumble, darn it. But you can catch this on my new YouTube channel. I'm going to go live to Rockfin as well. I'm going to share that link out for anybody that would prefer to be on an uncensored platform. I did recently lose my channel to censorship. So thank you for being here. Thank you for subscribing, if you don't mind, to help me get a little bit of traction with that new YouTube until they kick me off again. We'll see how that goes. I bust up to 100. So thank you, everyone, for anyone who has done that. After we are finished the live today, it is going to also get uploaded to iTunes and Spotify and Anchor FM and several podcast channels. So a lot of different ways to share this. We're also live on X, which has been new for me recently. And you can always visit my blog, bethmartins.com is a place to start. Also, the King Hero, just hit the King Hero tab there if you want to go back and see any other interviews. All right, so we're going to get started and hear about this ruling first. If you can fill in the blanks for anybody that might not be super familiar with it. Jane, do you want to go ahead and get started with that?
Sure.
Okay, fantastic.
So that was January 23rd, 2024. The federal court, Justice Mosley, ruled that the Emergency Act invocation on February 14th, 2022 was illegal. He said that it was unconstitutional, unreasonable, and unjustified. Primarily, the biggest problem he saw was that there was no legal grounds to bring it in according to the Emergency Act itself, because the Emergency Act requires that the emergency meet the definition of CSIS Act, and it did not. And he also found problems with the Section 17 and Section 25 were not met. And I'll explain the unconstitutional part and using the charter. He found that it was a violation of freedom of expression, which is the term that's used in the charter, and assembly, and life, liberty, and security of person. I guess because there was so much harm done, like physical harm done. Many people got beaten, and some people sustained permanent injuries from that, and quite an extensive amount of property damage as well. So,
can I jump in with a question quickly, Jane?
Yeah.
So what were the implications? Say if they hadn't called the Emergencies Act, or better to speak of it in the positive, that since they did, what did that so-called empower them to do that they couldn't have otherwise?
Well, the way they did it, Janice has done a very deep dive into the presentation that was made to the Public Order Emergency Commission and what they testified to. And primarily from the way they described what they did there and the document itself, what they had done was they bypassed Parliament and brought that in just from the executive. And you see it in the order itself. It says, an order in council on advice of the Minister of Safety and the Minister of emergency preparedness. and that would be Lametti and Mendocino. So that's the executive of the Liberal Party, not the whole cabinet. And the act calls for the whole cabinet. And you can see a description of that in an article by Peter Rosenthal, which is on Canley, and I think it's called Emergency Act, 4 times worse or 3 times worse or something than the War Measures Act. But he describes in there that it has to be brought in through cabinet. The entire cabinet has to be presented with it. But he played a little, like I guess, it's kind of like his father did, a lot of, whatever, dancing around. And so what they did is they went to the cabinet and they said to the cabinet they want to bring in an emergency act. They forgot to mention that they'd already got a decision from CSIS saying that it didn't meet the criteria.
They forgot.
They just forgot. That's section 3. They just forgot to mention they didn't meet that's what they're supposed to do first, is have the grounds. Okay. So then cabinet had an agreement, consensus, that Trudeau could go and speak to the provinces and then do whatever he wants. Well, that's not what the act says. The act says they're supposed to meet with the provinces, get the consultation, then go to the cabinet and get the cabinet to bring it in, to pass it. That's not what they did. They bypassed. So that gets to the kind of core of what we're alleging, that it's treason, because they bypassed Parliament when they did it. But unfortunately, that did not get emphasized on this decision. I still love the decision anyway, because it's killed it. And I don't think it's a ploy of any kind. It means some people think it's just a ploy to, get it at a lower level court and then bounce it up and then get it permanently established that they could do what they did there. But I don't think so, because the way the decision is framed, I don't think there's any wiggle room whatsoever. Like, if there's just nowhere to go, there's no gray. It's pretty, like, they're supposed to do this, and they did this. Supposed to do this, and they did that. So they have to find a mistake in fact or a mistake in law in order to qualify for an appeal.
For sure.
So,
And I want to ask you about that, but if I could jump in with a question, I'm curious, how would it have looked differently in Ottawa when everybody was there? So the big thing that sticks out in my mind is that they had not only the RCMP and the local police, but they had a huge crowd of, what are they? Where did they come from? We couldn't even recognize
yeah.
the armor they were wearing. It didn't look Canadian at all. I just wanted to also quickly say hello to people in the chat who are here. Looks like Rumble is working, because we have people on Rumble, so that's fantastic.
Okay,
Good to know. Good to know.
Just one more thing to give an overbrush. They also found it was a breach of Section 8 of the Charter, which is unreasonable search and seizure. Now, I would have apparently Patti can speak to that. I won't get into any detail, but she presented and watched a lot of the presentations. So apparently they did use the bill. So I would have preferred that, instead of, like, what they said is that the act was not invoked properly because they didn't have grounds and so forth. Therefore, they couldn't use Section 1 to say that their violations were justified. But I would have preferred to see the bill used, because you're not supposed to violate even in the case of an emergency. It doesn't allow you. There's no room. And it's the same rights. Like, you have a right to freedom of speech on both cases, freedom of assembly, and also the right to protection from unreasonable search and seizure. So you have all the provision in the bill, but it would have been much better in terms of scolding and making sure that they didn't come back and try to give us another round and say, oh, well, this time we have the criteria, because they create things. I think that what was going on at Castleman, I think there was an operation that was in play, and not through Norm and the people that were developing this convoy, but the convoy, I think, was going to be used as an operation. And myself and Janice and V. Gandhi kind of put a damper on that. But that's what they can do. They can create their whole scenario. They can pay people. They can even pay people to go do some jail time, and then create their grounds, and do it again. Like, do something that does qualify. Because what they were saying there, with Castleman, there was a leaked tape recording that said this group was going to blockade the business section in downtown Toronto, and they were going to make a second line that was going to protect if the police attacked. They were going to surround the police, and then whatever. And they also had a public statement made by Jody Ledgerwood and somebody else that confirmed, said that they confirmed the authenticity of that tape, that it did occur with a planning meeting for the convoy. And they heard more things, such as they were planning to apprehend ministers and then negotiate with the government, like MPs. They're going to kidnap MPs and then negotiate with them. And that's not Norm. That's not what he was doing. We know him very well. We worked with him for about a year and a half. That's not what he's trying to do. That's not what he's doing. That was all being, piled on. And luckily, that big clash kind of put a damper on the plan, and it didn't happen. And the ones that were really, like Norm and others that were managing the camp, they put their foot down. They kicked out a bunch of infiltrators, and then they made rules for people coming in. They were screening them to see what their political position was and all that kind of thing. So he kind of, I think, narrowly escaped a very serious whatever operation. And he would have been experiencing the brunt of it, because he's the organizer, clearly, and they have this new and improved way of proceeding with charges by saying if you're a party to it, and it's really loosey-goosey being done. But he couldn't deny that he was a party, because he's a main party. He would have been in big trouble if they would have created that, like, given cause, they'd come in and arrest everybody and then don't let them out on jail, like the Coots guys, and just do it up. And in the meantime, they'd have their cause, you see, because it's not, they don't go to court and go through a whole process of proving they have grounds. They just have to create a flavor or a sense, and then they can just do it. So I would have preferred the decision confirmed that even in a state of emergency, they can't override your rights. They can arrest you. That's a violation of your liberty, but that's when that's been properly brought in through rule of law, where certain, like all the things in the criminal code, or most things, you can lose your liberty if you do those things. But
Right. So,
like freedom of speech,
Mhm.
that's never, you're never supposed to take your freedom of speech. Even if you get arrested, you're still supposed to have your freedom of speech.
Right. And what about all the violence? Do you guys think that the violence would have been so intense, like being walked on with a horse, being beaten, being, I know, Janice, if you want to speak to this, do you think that if they hadn't called the Emergencies Act, that they would have resorted to that kind of violence?
No, I definitely don't think so, because up until that point, the police had been pretty friendly, and a lot of the convoy people, just organizers or participants, whatever, there'd be a lot of friendly exchanges between them. And when the Emergencies Act was brought in, it was totally different police. Like, they weren't the old friendly faces like that we were familiar with. And of course there was like rotations and stuff, but these were new police that were brought in.
Who were they?
Well, a lot of different ones. There was Toronto Police, there was Durham, OPP, OPS. I know Quebec Police were brought in as well. Some of those were the ones that we saw in green. So do you know about those ones? I know a lot of people have been talking about there were UN planes that were seen land and busloads brought in. I haven't personally seen any evidence yet of that. I'm working on putting together a criminal incident report, but I'm not stating anything about UN or foreign police being brought in yet, because we don't have that evidence to back it up yet. So at this point, we have a lot of people saying things, but we need to see like some video evidence, something like that, photos. I mean, so if you have anything, send it on in. but
Yeah,
everyone
I,
used to- yeah, go
go
ahead.
ahead. Sorry. I've got two witnesses that I know quite well that heard them speaking Ukrainian. And one, he's in Toronto now. He told me that they had knocked him to the ground and then hit him on the head with a rifle butt and broke three of his ribs. And they were speaking what sounded to him like Ukrainian. And I did see the buses, and someone has sent me pictures of the planes at Sudbury and North Bay. And I think what we can do is we can check their airport records. It must be on, they must have had a record of it. So I think we need to contact the airports.
Well,
All right.
There
Yeah.
was also an email sent out by Keith Wilson to all of the whatever people participating with his group, telling them, ordering them, do not talk about the planes that came in with people coming to the protests through the north, planes coming from the north. Didn't spell it out, but it's another little flag, I would say.
I've got also got two people that I know very well. I've known them for years, and one lady exercises racehorses, so she'll actually run the racehorses, and the other lady for decades now has been a horse trainer. And if you look at the video of those men on the horses, they both said it looked like they had only learned to ride the day before, because of the way they held the reins, and one guy had trouble staying in the saddle, and the horses were not police horses. This one lady said that they were horses that were bred for meat, and they would be shipped over to France, and
Hey,
they were.
Norman. Yeah. I totally want to hear all of this. Do you mind to introduce yourself for people who don't know who you are and what brought you to the panel today?
Okay. I met Jane in 2020, or was it 2019? I met Jane, and I took Trudeau to court in 2019 for the SNC Lavalin matter. I filed what's called a private prosecution, which you have every right to do in this country. And Jane was there. They locked me out of the courtroom and said they stayed it for lack of evidence. Now, you can look up on CanLII, you can look up Traversy versus Trudeau. It's there. I've got a transcript of the hearing. And
but you should point out, Norm, they didn't allow your evidence in because they locked the door. Like when he filed his information, you just state what you have. You don't show them what you have. And then the purpose of the hearing is to show what you have to the judge. So they blocked the door. He had four boxes of documents.
And they invoked the McHale principle, which is a Supreme Court principle for evidence for a matter to go forward. And I had Gary McHale standing next to me, that the principle's named after. And he had spent the weekend. Yeah, he had spent the week.
So just fast forward to the current situation that we're in with the C word, as Glenda just said. That is, I say boogeyman virus. So just if you guys can follow my lead in preserving our ability to stream here. You were apparently one of the original organizers of the convoy and are again ready to press charges against Trudeau.
That's correct. On July 1st, 2020, I gave a speech on Parament Hill, and you can see it on YouTube, on Amina M, her YouTube channel. And with the help of Jane and others, we had 192, I wrote 6 pages of 192 pages. So they put this together and charging Trudeau. And I gave the speech to 5,000-6,000 people, and then they followed me to the American Embassy and we did deliver it to them, and then
Yeah, and they were yelling, Norman, Norman, Norman.
yeah, that was insane. And a day later, we went to the Mexican embassy and delivered it. I got a receipt from the White House, and I got a thank you email from Donald Trump. So they knew who I was. The American military contacted me. And then for the convoy, there was Pat King was with me when I gave the speech. We kept in touch. A man named James Bowder had the concept originally, and he is a trucker, and the Canadian Truckers Association contacted James, who'd been already done a couple of convoys, and said, "Will you do one out to Ottawa?" And he agreed. And apparently, they gave him their database of all their members. That's how he contacted so many people. And then he contacted Pat King and asked him if he would lead it to Ottawa. So Pat did not organize the convoy, but he did lead it. And I was part of the reception committee in Ottawa. I know the owner of a boutique hotel in downtown Ottawa, and I asked her not to book any rooms unless they knew me. And so we ran the thing from the Swiss Hotel in Ottawa. We had two ladies that were doing logistics, and one of them ran the hill. And we ended up delegating. We had what was his name? Bulger, Danny Bulger, ex-RCMP, ran security. We had someone who had a trucking company that ran transport for us. We had logistics. We had a dozen licensed paramedics. It was all organized really, really well. Then Tamara Leach showed up at about day 7 or 8, and she showed up at the hotel. And she was not an organizer, and she was putting out press releases and actually negotiating with the police and with the mayor without our consent. And I remember opening the door for her at the Swiss Hotel, and she came out with 2 other people, and she was dragging a little cart behind her, and I wondered what was in there. And she walked to the War Memorial where they arrested her. The whole thing was planned. Now, I tried to intervene in her case, November 28th, I believe it was. And her lawyer and Chris Barber's lawyer sat with the Crown and opposed me. I said I wanted to intervene on behalf of all Canadians, and that there was no jurisdiction for this court that they were in because they couldn't deal with matters pertaining to the Bill of Rights. And what was it? Inherent jurisdiction they didn't have. I stated that. I said this is a human rights issue and needs to be heard in the Superior Court. And they opposed me, and the judge said that it was up to them to decide how the hearing would go forward. And they threw me out. So that tells
you. It's ridiculous because intervening doesn't mean you're in support or part of defense. You can go against, like an intervener can go in and say, not that you were doing that, but it's not up to them. An intervener is supposed to be somebody that has a different perspective and a different argument or different evidence for the matter.
Yeah, and this affects me too.
Mm-hmm. It's everybody's rights.
Yeah, so the convoy was hijacked. Patti, did you want to say something? Would you mind to introduce yourself first as well?
Hi, I'm Patti. I was actually part of the hearing before Justice Mosley. I had to do
and Justice Mosley, just to be specific, is the one that that made that ruling that we're talking about today, correct? Yeah. Okay.
I'm part of the Canadian Constitution Foundation, and I had went in several Zooms with the lawyers of the Canadian Constitution Foundation. Prior to that, when the Emergency Act was enacted, I wrote a letter directly to Trudeau, and Garnett was one of the MPs that had endorsed my letter to Trudeau, because I was really appalled at how our peoples were being treated in Ottawa. That is unceded Native territory. I am First Nations, and it took great pride to watch the citizens of our country gather in the manner that they did. So I felt the need to reach out to the Prime Minister to apply the law to say that you have violated the Bill of Rights, you have violated Justice Sinclair's reconciliation report, and furthermore, the reconciliation of our country when our First Nations people have always asked for this. This was something the truckers did that you could never do. So it was in the middle of the night that I received an email back, and they thanked me for writing the letter, and the Emergency Act was withdrawn. So I then had to do a written statement. I did a written statement, and then they requested me to do a recorded video and submit it before the Special Hearings Committee. So when Justice Rouleau was doing his, I was on the other part of the commissioners. So my evidence was brought in. So when the Canadian Constitution Foundation, I was very honored and blessed for them to have me watch the hearing before Justice Mosley. There was actually 5 matters before the court. There was the Nurses Association, the police. There were several people that brought this judicial review before Justice Mosley. So what they had did was the Constitution Foundation had joined with the Civil Liberties Society because they were very good lawyers. We had to hire 2 international lawyers to bring the documents together because we needed to use the Vienna Convention Treaty and apply it to the human rights of the peoples of Canada. And also, there were several other legislations that were brought forward. We had to use part and parcel of the convention, but we also had to take the Bill of Rights to apply to the charter. This way, those rights were protected. And it touched my heart when Justice Mosley spoke on the bench, because it was actually brought up, John Diefenbaker, about the Bill of Rights. And it was spoke about before the court. So a lot of people have the misconception that only the charter was applied. I know the Justice Center had applied the charter. They didn't choose the bill. But in all actuality, you really needed to use the Bill of Rights to apply to the charter, in which the lawyers did. Christina
from the Constitution Foundation, they're the ones that brought it.
Yeah. The Canadian Constitution Foundation was the one that actually, and if you read it into that article and into the order of Justice Sinclair, Justice Mosley, it does states without the Canadian Constitution Foundation and their expertise and what they've gathered, there was over 7,000 documents submitted before the court. This is why it took so long. The hearing the judicial review was applied for immediately in February of 2022, but it was not heard until April 3rd to 5th of 2023. And we just
we just recently found out through a conversation with Dave Freedom and Dave Cowling, which is one of the lawyers from the Canadian Constitution Foundation, that 2 of the lawyers worked for free, pro bono, for an entire year, and they said it was almost full time every day.
Yes,
and volumes and volumes and volumes of paperwork and organizing. Like they had to organize all the witnesses. They did all the arrangements with Patti, for example, and many other witnesses that came forward. They had to organize that all.
There was a lot of dedication and time.
Just to jump in quickly, Patti, that the lawyers worked for free I'm assuming that's an indication of how incredibly important it was to them. Just want to say that out loud. Okay. Yeah.
Yes, it was. And it was on behalf of all Canadian citizens. It wasn't just on behalf of the trucker convoy. Because in that hearing before Justice Mosley, the Emergency Act, if people can be aware, was only restricted to Ottawa and Ontario. And it actually, if you look back in November of 2021, Jagmeet Singh had went to Trudeau and asked him to enact the Emergency Act in Ontario only. And so it was, to me, premeditated. And I'll stick to that I feel it was still premeditated. But irregardless, they did enact it. There was only 3 provinces that agreed to enact the Emergency Act. And all the other provinces said no. They
Which ones agreed?
They bypassed cabinet, and they acted without lawful authority to enact the Emergency Act. But the Governor General was part and parcel to that because she affirmed to go ahead and do so. So she overstepped her boundaries as well. She let down our First Nations people, and this is why I stand on principle. And what they did to our citizens in Ottawa, I actually witnessed Chinese flags on the pole. My blood was boiling when I saw that. And this is what really made me write that letter to Trudeau. And I'm aware that there was foreign police, especially from China. They identified themselves as from China. They had black suits and a red hat. I'm not sure the direct address, but there was video of those being on soil, as well as Ukrainian people.
Patti, quick question. Which provinces agreed to the Emergency Act?
Saskatchewan was one of them. Nova Scotia was the other. And I'm not positive. I don't want to say for sure.
Janice might know that. She's
Yeah.
our kind of expert on that kind of stuff.
Yeah, but
not off the top of my head. I'd have to look that up. I could probably find it somewhere.
Okay,
lot
yeah,
of-
I'm
lot
just
of
curious.
the
I'm not surprised to hear about Nova Scotia because everything I've heard about that is pretty dark.
a lot of the evidence I pass along to Janice, and then I try and answer some of the questions because, no offense, but sometimes if you're not there in person to see the hearing, you're not really comprehending what has transpired. It's unfortunate that I had been asked by the Canadian Constitution Foundation to invite people to the courthouse, but they thought it was a charter application. They don't have the understanding of the law. If you've never studied law or learned anything about law, this is where you can get the misconception of applying the charter. But people need to realize some people within that hearing did apply the charter, but the Canadian Constitution Foundation were wise enough to know that they had to use the bill, one section of the bill, to apply to the charter in order for it to override section 1 of the charter. And this way, by applying that act to that act but in law, and Justice Mosley applied the law. So, and one other thing I will mention, Justice Mosley actually was a truck driver. He was from Alberta. And it was nice to hear him talk about recollection of him sitting there driving in the truck. So there was no bias there because he chose to apply the law as opposed to think that he was a truck driver previously. On the appeal, they had 7 days to seek leave to appeal. The grounds for them to appeal are based on economic. But there's actually, that was brought up also in the hearing about economical loss. It was the causation of the government that caused the borders to be closed when everybody was in lockdown. So when we were in lockdown, a lot of people weren't spending their money because they were restricted. And if they were out in public, then they had to be masked or they were refused entry to certain establishments. So in order for the appeal, it's going to be very, very difficult for them to appeal based on an opinion, because you have to, like Jane said, you have to have a fact And a lot of the facts were already proven before the court and any point of law, but there's not really many points of law that they can use for the appeal. But they first have to seek leave to appeal, which is within the 7-day time frame in order to appeal that decision. So
Sure. Which I want to get into that more. I'm just curious about, like, who were the parties in the suit? Obviously, like, was it specifically to Trudeau, or was it the executive of the government? Like, who are the parties?
I can answer that. It was a judicial review, which means they were taking the decision itself and reviewing it. So
Okay.
that's why in the end of the day, they found that it was unreasonable. That falls back on the specific decision makers, which are Trudeau, Freeland, Blair, Mendocino, and Lametti. Those.
Okay.
Those
So
are
there's no
makers.
plaintiff, no litigant, no. It's judicial review is different.
Not
Okay.
yet. Not yet.
Not
That's
yet.
coming. That's coming.
Right. Okay, that
I'll
helps.
explain that a little bit further. It was originally the Canadian Constitution Foundation that brought Trudeau and his cabinet to court because they were aware of the violations of our rights. So they brought the judicial review to the court first. Then what happened was the Civil Liberties Association had asked to join in conjunction with them to apply the judicial review before Justice Mosley against the illegal enactment of the Emergency Act. So the Civil Liberties Association had joined with, but there was 5 hearings within that judicial review. It's very hard to get court time, and the court process could be long, and it was needing to get to the court fast. So what they did, they decided to take all 5 applicants between April 3rd to the 5th, and then they turned around and each party had a length of time to speak or defend their argue their legalities. But the first one was the Nurses Association. It didn't take long, and like I said, they only applied the charter. The lengthy one, and Josh, he did an excellent job. So I really commend Josh for the arguments that he did make. And I had to laugh during the hearing because the Ministry of Attorney General actually applied a case law from Canal. And the Canal case law was in the favor of actually us. So I guess they didn't read the whole article within the Canal legislation or law that the Supreme Court of Appeal had already heard. So it was in our favor. And Josh when it was then he brought up about the Bill of Rights, the Vienna Convention Treaty, because like I said, the Vienna Convention Treaty deals with the human rights part of it. There was also bankers there. They were appalled that the people's bank accounts were frozen. And it caused havoc between the different associations for what had happened. Because, I mean, like I do a lot of legal work myself. I'm self-representing myself in court matters. I've won several matters, and I have the knowledge. So I was glad to be part of the hearing, and anything that I have experienced within that court, I wanted to share with the people. So I'm reaching out to people because if they do appeal, court costs are not cheap. And these lawyers have been working for free on behalf of every Canadian citizen. But what affects every Canadian citizen also affects worldwide, because we have peoples that are Canadian citizens living in other countries. And you look to see what happens in Germany and France and what's going on now. And we have to commend our truckers in the Convoy 22, and Pat King, George Billings, Bridget, Norman. God bless you all for everything you did. And what had happened on ground just still to this day affects me. A lot of people not maybe have been on ground, but they witnessed it like I had witnessed it on the many live videos. And I'm internationally connected. I'm an ambassador of peace. So I reached out to peoples across the country, across the world. And I'm also connected to radio and TV. So I said, look, this is what's going in our country. You need to see this. You need to experience this love and unity. But when the police come on, that, like I said, my blood boiled. So I'm very appreciative to be a part of the Canadian Constitution Foundation. I'm very proud of their work. They did excellent work. If you can follow them on their page, there's several podcasts where they'll explain what happened in the court. They just summarize it up. But in order to understand a lot of it, if you were there in person, possibly you could understand more. But Christina, she actually starts to limit, and she puts the top 10 points or summarizes it so it's easier for people to explain.
So, Patti, why don't you send me some links that you'd like me to share out on the stream today? And Janice, I didn't get you to introduce yourself at all, and I know you had very profound, big experiences at the convoy, and you've been through a lot. Do you mind to share with us what that was like?
Sure. Yeah. So prior to the convoy, like I had absolutely zero interest in anything political, legal, anything like that. But I just been seeing and hearing about all the effects that it was having on Canadians, job losses, divisions in families, all that kind of thing. And obviously that's, really wrong. And I just felt that I had to get involved somehow. And I knew that if I didn't go there and, experience it and see what was going on in person, I wasn't actually going to understand what was happening because, news isn't very accurate. So I went up and I joined the convoy and I met up with them. Met up with one of the convoys in Niagara on the Lake. We stopped overnight, did the slow roll with them, and went to Ottawa. So I was there for the whole thing. So yeah, it was pretty much every day. I think I only didn't go down a couple days because I spent some time with some friends there. But other than that, I was on the ground every day, morning to night, just kind of helping out, learning, talking to people, that kind of thing. So.
And how did that altercation go when you got into trouble and then you've been through some court process yourself?
Yeah, so that was at the end when we heard the Emergencies Act was invoked, and then all the police were closing off roads. And on the Thursday, I decided not, because I've been spending the nights over at my friend's place and then coming back to downtown Ottawa, Coventry, all that in the morning. But I didn't go back to their place that night. I just spent the night in the car because I knew if I left, I'd be blocked out by the time we got back in the morning. So I spent the night in the car, and then the next day was February 18th on the Friday. And that was the day of the crackdown, and I ended up getting arrested and went back the next day, got arrested again. And then at that point, of course, because the whole bunch had a bunch of charges, that's when I heard about Jane and Rebecca, and they helped me out with doing self-representation in court. So I went on their Zooms. They had Friday night Zooms every week. So I started learning about law, self-representation, the Bill of Rights, case law, and represented myself in court and got the charges dropped. So, and then
you got to tell about the best little highlight there, the one where the judge was talking with the Crown. We love that. We talk about that all the time.
Yeah, that was actually pretty good. So, in court, which is over Zoom. So I've gone, like I said, I went back twice. So I got arrested the first time on the Friday. That's when the police, they knocked me out. I got my back and neck messed up. But I went back the next day and finally managed to get in because at that point, all the police had blocked off all the roads or put up gates. I finally managed, it probably took me about 3 hours or whatever, but I finally managed to get in, climbed over a little wall and got in. But I got arrested again. But I was bringing back in a bunch of waterproof gloves for the truckers because I've been helping out at one of the donation tents, and that's one of the things we were kind of short on. So I stopped at Coventry that morning, got some gloves and stuff, and was coming in. So fast forward to when I went to my judicial pretrial, and evidence and stuff was coming out, and the judge heard that, and she said, like, that's humanitarian aid. So it's really great because she's like pretty much like defending me, and it was great. I didn't have to do too much talking, which
she said she didn't see any mischief.
Yeah, she's like, that's
she
not
saw
mischief.
that she was doing humanitarian.
Yeah.
But what did she think of the violence that you got injured? Do they?
Yeah,
did
exactly. Well,
did she not
there
address
wasn't ruling and stuff on any of that. It was just like to go for my charges because I had like 4 charges of so I had like 2 counts of mischief. One was obstructing police and disobey court order. So anyway, she was defending me, going like, well, was there signs saying that you can't come into the area? And well, she was bringing waterproof, she was bringing in, gloves to truckers. That's humanitarian aid. Like, that's not mischief. And it was just really good. So.
And then shortly after they dropped the charges.
And so it's like, it shows like not all our judges are corrupt, right? So.
Awesome. Great point. Yeah, I love that.
I got a couple of things I can like
For sure, Norm. Could I also, just before we forget here, the 3 provinces that were for the Emergency Act, where they were in favor of it, was Ontario, British Columbia, and Newfoundland. And Labrador. I have to take back my Nova Scotia comment. So go ahead, Norman.
Okay.
Thank you.
I was getting phone calls from people to donate things. And I got a phone call saying, I've got 16,000 hot dogs and buns and condiments. Where do you want them? And another guy called and he says, I've got porta potties. You can have them for free for the duration, but you've got to set them up. So I'm an ex-firefighter. So I got off-duty firefighters to set up the porta potties. And I insisted on one thing, that they put a porta potty at every door of the Privy Council building. So we put porta potties at Trudeau's office. And the other thing was, as Janice said, they had shut down Ottawa so that you could leave downtown Ottawa, but it made it very difficult to drive back in. And I remember going on Laurier Street, which has a bridge over the canal and then leads to, eastern Ottawa. And there's a major intersection there, and the OPP, the Ontario Provincial Police, had three cop cars there blocking it so you could leave, but they wouldn't let you back in. And I made sure I timed it so there'd be a red light at the intersection. And I'd look at the cops and blow them a kiss and run the red light. And they couldn't chase me. They had to stay there. And I probably did that 3 or 4 times. It was funny.
Fantastic. Yeah, all those little beautiful ways to enact justice.
One thing I'd like to add on that, Norman, a lot of people aren't aware, like Ottawa is on unceded Native territory. There are public, or under the Highway Traffic Act, Wellington is one of them that is not considered unceded territory. So this is where there is a breach of justice in Claire's reconciliation report, and he is actually a judge, and he made the order. And I know I had a little bit of a argument with Algonquin chief. He's a little bit younger than I am, or a lot younger than I am, but I'm also a knowledge keeper. And I had approached him via one of the live videos that they were doing. And I said, look, this is part of our 7 grandfather teachings where we see all the peoples come. And under our 7 grandfather teachings and under the 1850 Robertson-Huron Treaty, we are sovereign people. And people, not only First Nations, but all Canadian citizens that live on our lands are sovereign people under our sovereignty treaties. So there's so many treaties that I applied when I did my draft letter to Trudeau, because I had to point out. So I pointed out this to the Algonquin chief. I'm not on his good list, But at this point in time, when one of the younger chiefs, I'm a hereditary chief, I'm above the chief, because I am hereditary. He's elected. So I told him, you need to apply your 7 grandfather teachings, because some of the Native people didn't want our citizens in Ottawa. Well, it's no different when you're going there to bring in tourism. And then you're bringing that amount of people, you're bringing a lot of work to the people within that community, because a lot of restaurants and establishments that remained open gained profits, 2 weeks profits that they couldn't even 2-3 years that they lost, they gained back in 2 weeks. So the convoy, even though they enacted the Emergency Act, people need to realize they need to stand up for their rights, their freedoms, and under this sovereign land, you need to protect each other and stand up for each other, as opposed to backlashing and putting these egos aside. But I'm so proud of a lot of people that have stood up. Janice, for one, like she has stood up against Norman, the same. Pat King, I used to babysat Pat King. I know him very well, and I do have a lot of high regards for a lot of the people that were the organizers in this event. It was not a gridlock. It was a setup on Wellington Street to have those trucks moved over. And that was also part of my testimony, because I'm aware of that territory, and I'm aware of what's unceded land and what's not unceded land. And I provided the evidence to confirm under the treaty which part is unceded territory. And this is why I felt that it was a premeditated setup for these trucks to be moved to Wellington Street. And it appalled me when I saw them doing that. And I tried to reach out to a lot of people, but if you have no comprehension, I had an argument with a lady online. She said, no, that doesn't fall under this and that doesn't fall under that. Well, whatever. I'm not going to argue with you. Do what you will, but it needs to be addressed in some of these court hearings as well, that this reconciliation report of Justice Sinclair, as well as our treaty and the Bill of Rights. Because like I'm First Nation, I would apply Section 35 of the Charter. But other Canadians, if they're not First Nations or Métis, you have to use the Bill of Rights to apply to the Charter to ensure your rights under the freedoms of speech, freedom of assembly, etc. But you would also have to use your Vienna Convention treaty. Because when Trudeau enacted the Emergency Act, the main purpose was to change the criminal code. And this is what people need to become aware of, because they tried to change the criminal code to make it look like everybody was criminals. This is why they would charge people with mischief, because they didn't actually have a charge other than mischief. So just updated note on that.
Great point.
Speaking of the criminal
One thing
code,
I'd like to add before you go to another topic is the land that Parament Hill is on, and including the roads, all the way down to LeBreton Flats, probably, I don't know where the end of it is, but it could also include Tunney's pasture, was given in deed to the Algonquins for return for their help in the War of 1812. And it was never, they never forfeited the deeds. The government, when they wanted to use the land, they just shoved them off up to Barrier Lake, which is a really poor, it's not a very fertile area. It's like and they've experienced abject poverty there because it's just hideous. And that was in 1858. They just like shoved them off. They didn't pay them off and acquire their deeds. They just shoved them off. And the reason I know this, I saw the deeds. I did a protest in 1989 on Breton Flats, and we wanted to establish the ownership because somebody had said there's still, because the NCC was supposed to they did expropriate the land, and they were supposed to pay the individuals, but they didn't pay, so they never acquired deeds. Somebody had told us that, so we wanted to go and confirm who actually owned the land. When we got there, they brought out the big book, like they're huge books, and they put them on the table, and the guy from the registry said, "Oh, this is odd. What? Well, the Colonel Le Breton never acquired deeds. Algonquins have the deeds for this," and it showed starting in 1812, and they're still there.
Yes, and there's
And
actually
that includes Parliament Hill, because later, like in the 90s, I was told by the Barrier Lake group that, I met them in the 90s, but they had done a protest in 1960 regarding clear cutting and blowing up their streams looking for minerals. And they came there and they said, this, they brought teepees and everything. And I just, like, I was very young then, so I didn't know what was going on, but I do remember a picture of a First Nations woman sitting on two RCMP's hands, like she was sitting in the middle and very stoically sitting, very proud and stoic. And their position was, this is our land. You shoved us off of here, and now, where we are now, we're being pushed around and our land is being disrespected, clear cutting and this, so we're coming back. So they said, okay. And they gave them a deal, a tripartite agreement, which they said they were happy with until the 90s, after they after we signed free trade, the companies came back again, just pushing them. So they were starting up again, protesting again in the 90s, and that's when I met them. And they said it's all part of the same package, all like parcel of land. Probably goes to Tony's pastor too.
there's actually a big land claim in that area. Ottawa area is the biggest land claim in Canadian history. They're after the land. This is where these fake mock Métis pretend Indians come in, and they are actually people out there selling these pieces of paper saying people are Métis. Well, I know a few people within this movement that purchase those papers. Well, they're not lawful documents. And what happens is if they turn around and buy these papers with the Métis Association, a lot of them are against it with the Bill C-53, but it's land grab. So this is where they're trying to steal that land back in Ottawa, and then Parliament Hill. But to me, at least should be put on Parliament Hill for the time being up until this matter is rectified.
Very good. And Norman, did you want to chime in?
Yeah, a couple of things. If you ever need a place to park downtown Ottawa, park at the Supreme Court. I've parked there all the time. I've got no pass, but they can't ticket you there. And they certainly wouldn't tow you. And there's always a parking spot at the Supreme Court.
And why is that?
Pardon me?
Why is that they can't tow or ticket
Well,
you?
I could be in there arguing a case. And also, it's federal land, and Ottawa bylaw officers have no authority on federal land. And they don't have their own parking police. So I've never had a problem. Probably a dozen times I've parked there. And
all right, good tip.
Yeah, and I'll tell you, before the convoy arrived, a couple of days before it arrived, I got a phone call. I think it was Pat King called me, and he said, look, there's going to be 2 trucks show up the day before, and one of them is going to have food and like a camp kitchen, and the other one's going to have tents. And, get some volunteers together, and we'll set up on Parliament Hill. So sure enough, the trucks showed up. I had maybe 10 people with me, and we started unloading onto Parliament Hill. So the cops show up, the parliamentary police, the protective service, whatever they're called. And
protection service.
Yeah, they said, you haven't got a permit. I said, I don't need a permit. There's like 10 of them there. And we kept unloading, and they said, well, we'll just load it back onto the truck. And I said, everybody sit on the tents. So we all sat on the tents, and they didn't know what to do with us. They couldn't drag us off. We hadn't committed a crime, and that would be assault. So then finally, the boss showed up, and she had a bunch of I think it was crowns on her shoulder, and she's got a binder, and she's saying, "You're in violation of this, that," and I said, "I don't care." I said, "Things have changed." I said, "You're not in charge anymore. I'm in charge." And she said, "Okay." And she said, "I'll show you a good place to set up." And I had plans to set up a village on Parlement Hill. Well, then the guy that owned the trucks gets a phone call. And he was told, "Oh, they're going to yank your license. They're going to take your vehicles and, this, that, and the other." And he knuckled under. I said, "Look, we won. We can set up here." And that's why it ended up being on the sidewalk and not on the hill. And I found out it was one of our people that called him. Another infiltrator.
There you go.
Yeah.
Craziness. So I wanted to ask specifically about all of the people that are now in process with a trial, have been charged. Maybe they don't have the knowledge that this group does. What do you think? There's two questions here. Maybe I'll ask the first one about if you're familiar with, I don't know how I'm pronouncing his name, Saba Vizi, who is in his, I believe now his third criminal defense lawyer, and not breaking ground. What implications does this judicial ruling hold for somebody like Saba, if I'm saying his name correct?
I can answer it, I think.
Go for it.
They have kind of stepped down on the charges of obstruct police and not obeying an order, and they focused primarily on mischief and counseling to commit mischief. And the mischief was confirmed in the Public Order Emergency Commission report, because they said they found there was an occupation and there was a blockade. Okay, well, Justice Mosley said no, that because if it was truly an occupation and a blockade, that would meet the criteria for emergency, because there's so many people and it was protracted and whatever. But they didn't in each case bring any evidence of the mischief. They just took judicial notice that this commission found it to be a fact that it was an occupation and a blockade. But now that card has been taken from them because Justice Mosley's trumps the Rouleau's, because that wasn't an official judicial process. It was loosey-goosey, and they had lots of leeway about what they accepted and how they accepted and how they used it, whatever. They didn't have to follow the official rules of evidence from the Evidence Act and precedents, how to use evidence and all that. So out the window. So judicial notice will no longer be valid. And in Byron Carr's case, they were doing mischief. He had 4 charges to begin with, and 3 were dropped. And his last one was mischief, and it was nonsense because even the judge said there's no evidence that Mr. Carr committed any mischief. And the Crown said, "Oh no, we have a case here because he was a party to the protest, and if he was a party to the protest, then he's a party to mischief." But they weren't even making a case about who did the mischief and what was exactly the mischief or whatever. They were just taking this automatic, it was because the commission had it. So that's gone. And what happened last week is the judge in Byron's case was working on his decision. Like the trial was completed, and he was supposed to issue a decision on February 14th, I think it is. Mm-hmm. But they called and said they want to reopen the case so that they can accept, because Dave Freedom and Byron sent Justice Mosley's decision in there. I think it's 190 pages or something. They sent that into the judge, and they said they wanted it to be considered in his ruling. So he contacted them and said he wants to open up the case, or open up the trial, so that he can accept this as evidence. So they're looking at it more than just a decision, because if it was just considered like a case law, then they wouldn't have to do that. But he's taking it as evidence.
Okay, amazing.
That would be evidence that counteracts and trumps the previous evidence that there was an occupation and I think some of the convictions can be overturned as well, because that's the new evidence. You're allowed to bring when you have new evidence.
Right. Patti, would you like to say something?
The other thing is, a lot of people are forgetting that Justice McLean had already made an order before the court. The order was that the protests were people in Ottawa were still able to protest because the protest was peaceful. The only thing there was an injunction for the horn honking. So if anybody did honk the horn, they would be subjected under the criminal code for breaching the order of honking the horn. But the order,
that would just be civil. That would be civil, actually.
Yeah.
Yeah.
Like it would be a small misdemeanor.
They still go through, and you can end up with fines and things like that.
Yeah, that's what I say, a misdemeanor infraction. But a court order is, like, even to me, my personal opinion, I'll stick to it. The police breached those court orders because those protesters were still allowed to protest lawfully. I witnessed Byron when Byron was being arrested. Byron didn't do anything wrong, and he's Métis. He had every right to be on Parament Hill to defend anything that he wished to defend. He wasn't
There's an exemption, because there was an exemption in the order for Indians, and there was a Supreme Court case, Regina versus Daniels, 2016, that found that the definition of Métis was part of the definition of Indian as per the constitutional definition of Indian. So Métis was included in that exemption. But then they tried to get around that by saying, well, he wasn't charged for breaching a court order. He had been, but they dropped it. And they said he hasn't been charged for obstruct police with regard to the court order. He was charged with mischief. But the what do you call it? The information sheet actually said he committed mischief by disregarding an order of police based on an order in council to remove his truck. That was exactly the words, and they try to just kind of shove that under the rug and pretend, oh no, it's this alphabet soup kind of mischief, and just make it nebulous and unclear, which makes it ridiculous to try and defend, because you don't know exactly what you're trying to defend, because you would think it's your information, because that's where they're supposed to spell out. Like your ticket doesn't spell it all out, but your information spells it all out, like what you did. It tells you exactly what you did. And they made another error in his case too, because I think it's 801 of the criminal code requires them to read the information sheet on the record and then ask them to plead guilty or not guilty. They skipped that because they wanted to leave it nebulous. They wanted to make it difficult for him to understand how he was supposed to defend, because they just made this loosey-goosey thing. And then in the submission is when they came out with this party shit. It didn't say in his charge, it didn't say you're being charged as a party to, right? It says you're being charged for mischief. And then you think, well, they don't have anything, so there's nothing to defend. And then at the end they come out with, oh no, it's your party. So that's when he asked for, he wanted to, I made a video where I took one of the videos they were using that they took off of Facebook, and they were claiming that they knew the date that the video was taken, and the subject. So they got the judge to agree that the subject was Byron. So they didn't really care if they were confirming who made the video. And they're supposed to. The rules of order or the rules of evidence, they're supposed to authenticate, and you're supposed to authenticate by having testimony of the author, but they just skipped that. And so then we brought a video expert in, a really good one, like from New York, Connor McCourt, and he testified that, well, like I had a video that's what opened it up, because I made a video where I took one of the videos they used from February, and I just took my phone, like played it on my computer, and took my phone and made a video of it and put it up as live. So when you went on my page, it looked like that incident took place in January, not last February. So that confirms that they can't just say the date on Facebook Live proves the date that the incident occurred. That just blows that away. But then they said, well, he's going to have to show that I am a video expert. So we thought, okay, you want to play that game? We'll get an expert. So we got this expert from New York. From New York. He was on the New York police for 20 years, and he was a video expert there. He has all kinds of credentials. And he said they can't use anything off of Facebook as forensic evidence because they can't confirm the date because of being able to, streamline an old video and make it look like live. And also because it never shows the time. So it could be anywhere from a 12-hour period. So it's not forensic fact. So he blew away all the evidence. And the reason they were giving us a hard time because they had said at one point to Byron, do you have any more evidence? And he said no. So then it went into the Crown's submission, and the Crown starts saying that he has all these videos to prove that he's a party. Okay, so all of a sudden now they're giving their legal theory at the end of the game. So Byron said, well, now I do need to address this so-called evidence of party. So they allowed it, and they allowed the witness to come in, and they had 108 screenshots from videos and 8 videos, all out the window.
That's amazing. Good to hear. So just looking at, again, what are the implications, maybe particularly for the Coots boys, because they haven't gone to trial in 700 plus days?
No implication for them because they
Zero.
They were hired, or not hired. They were arrested before the emergency was.
The other thing that was brought up in the hearing before Justice Mosley about the Coots 4, and it was brought to Justice Mosley's attention that they had been held as political prisoners, and this was what Jane was saying. The Emergency Act had not affected. It was not anything connected to the Coots. The Coots were charged under the criminal code. So in order for those Coots 4, they would have to be tried criminally. So it wasn't fought any further in the court before Justice Mosley, because Justice Mosley said the Emergency Act was only restricted to Ottawa. The Ambassador Bridge incident had been already cleared. The Coots border had already been cleared before the enactment of the Emergency Act. And
the only way it relates is in the order itself, they claim that because of what happened in Coots and in Windsor, and in Ottawa, they were saying in those 3 spots, this was giving them the grounds and the cause, but it doesn't revert back. Like, this invocation took place after they were arrested, so it has no bearing on what they did. And they weren't charged with I think they did have, I'm not sure if they have a blockade charge, but it's other kinds of charges.
No, like with the Emergency Act, like Justice Mosley said, that there was the the Emergency Act was enacted and restricted to Ottawa. The borders at both the Ambassador Bridge and Coutts were not affected because the borders were open previously to that. And any of the other province, like I live on a border town myself, and our border was open, we had no problem. The Sarnia border was open, there was no problem. The New York border was no problem. But this, when that was brought up during the hearing, this is when it was mentioned that it was restricted to the Ottawa area only.
Mm-hmm. Yeah, because Windsor had a court order, and theirs was open, I think, a day or so before this emergency order came out. Before we finish, can we put the attention on what we can do with this, what we have come up with in terms of what can be done with this decision?
Absolutely, Jane. One question, if we'll go for the negative. So there are people out there. There's somebody in the chat on Rockfin who is saying, you know, so what's actually going to happen as a result of this? And I would easily go towards that too, because you can get good news, and you know, and then it just fades. It's news for a day. It's not news tomorrow. Everybody forgets and nobody cares. But knowing you guys, you have been tenacious, beautifully tenacious from the get-go, right? How long ago has this happened? And you're not letting go, and you're not letting go, and you're not letting go. I don't think you're going to let go now either.
Oh, no.
So I just wanted to give you a lot of credit for that.
This is the biggest hook we got in so far.
Yeah. Yeah.
We're not going to let that go.
Yeah.
We have a number of things. I'll do one. One is I did a template for a statement of claim in small claims court. And Norman is working on, I'm helping him, but he's taking the lead of trying to charge Trudeau with treason and use this ruling as part of the whole allegation that's outlined in the incident report that Janice has been working really diligently on, like we all did, but she's recently putting all kinds of new evidence in it, and this is going to go in at the findings, some of the findings that this justice has found. And then there's class actions, and there's another woman in Ottawa, I haven't met her yet, Amanda Purdy, who's created a template. She's paralegal also for small claims court as well, for suing police for the more violent things, and for the bank account closures and stuff like that. So I don't know how you want to start, but that's
Okay.
Oh, and there's one other thing, a petition, and I can get Janice to outline that and where we're at with that. A petition.
Absolutely. And Janice had shared here some of the, is it case law? Anyway, Janice, I'll get you to talk about it so I don't mangle your note there.
Sure. Yeah. So I just wanted to mention, and this is something that people who are charged under the Emergencies Act can use in their either in their defense if they're doing self-representation, or they could also, I've also have it in the criminal incident report. But this came up in the, where was it? Okay, so this was March 29th at the Special Joint Committee on the Declaration of the Emergencies Act. So Parent Beatty, he was the author of the Emergencies Act. And so the Joint Committee, the Special Joint Committee on the Declarations of Emergencies Act, they actually got to talk with Parent Beatty and question him about different aspects on, well, what does this mean in the Emergencies Act, and what did you mean when you wrote that? So one of the things that he said was, and I'll just read to you his quote here. Parent Beatty says, "If you are looking at the actions taken by the government flowing from the invocation, and if you uncover evidence indicating that the invocation of the act was inappropriate, then everything that flowed from it was inappropriate as well. It seems to me that they are part and parcel of the same thing."
Yeah.
So that's pretty big, because I mean, obviously that follows that all the arrests, everything like that, all the damage to property, were also unlawful because the invocation was unlawful. And also, even if the Emergencies Act was invoked lawfully, which obviously it wasn't. But even if it was, the police still have to abide by the Criminal Code of Canada. Section 26 speaks to use of force, like excessive use of force. And also Jane put together, she mentioned the information on suing Trudeau. So I have a link in there that talks about like excessive use of force and the limits that police are under. There's a really good document that's linked to that as well. That would be very helpful for you guys if that's something that you're interested in taking on.
Yeah. So in that statement of claim, it's for freedom of speech and freedom of assembly, but we're also indicating that there's also assault and property damage and the unreasonable search and seizure are other kinds of claims that people can make. And Janice put a link in. I don't know if we put a link into what's her name, Amanda Purdy's. Maybe we should put that in there too, because she goes more into those issues, and she's recommending to sue the police. We're recommending to sue the executives of the Liberals that brought it in. Like you have a choice, because the police didn't even act appropriately within the dynamic of an emergency. So even if there was an emergency, the police didn't even confine themselves to lawful behavior within that, because there was no provision for them to use assault on an unarmed citizen that's not presenting any threat. Like, what the hell? And there was some serious assaults going on with the one guy got like Norman was saying some guy was getting beat by the head of, or by the barrel of the gun, not the barrel but the handle of the gun, and
the butt.
The stock.
Yeah, the butt of the gun, and other kinds of, and actually Janice got quite a like police violence against her, and which caused some harm, and other people as well. So I'm not saying that I'm recommending that people don't do those things, but I've just created one for people who were part of the protest or wanted to be part of the protest but weren't able to do so because of this order. So that's just freedom of speech and assembly, and that's pretty.
If I could I just add something? A police officer, I was severely beaten to the point that he left me on the ground dead.
Oh.
And I actually sued the police, and I laid a charge against the police. And what I did was I used the Police Service Act as well as Occupiers Liability Act. There's several acts that I've used. And when I was before the court, I self-represented myself, even with criminal injuries, because I made a report to criminal injuries, and I had to go to headquarters at the police station in Toronto. They had told me with the assault, the excess use of force part of it is only when there's injury to bone or blood. So there's different types of assault. So if that person, say, for example, like myself, the guy broke my jaw, that was excess use of force. I had blood draining from my ears after he smashed the face on the hood of my car. That was excess use of force, drawing blood. So just be careful of which part of the criminal code that you want to use. But I used Occupiers Liability Act, and I used the Police Services Act, as well as different sections of the charter.
Okay.
I'm so sorry you went through that.
Thank you.
Yeah. So there's two things. One, Janice said we should talk about the petition that's coming up, no public monies for the federal appeal, but let's back it up. Maybe that's three things. Back it up and just talk about why their appeal is not going to work from everything I've heard. I also wanted to, on behalf of Chaba Sizzy, if I'm getting that correct, ask about maybe this one first. How will the ruling, now that we're talking about, change the ability for people seeking civil suits against law enforcement for battery or other damages as a result of the EMA, And this is specifically with a lawyer. So they don't have the advantage of being unrepresented. What do you guys think?
You have 2 weeks and a lawsuit in Superior Court. You'd have to find if you don't have the money, if you don't have a lot of money, you have to find a law firm that's willing to do it on a contingency basis, which is very difficult. There's a class action. A couple of lawsuits or law firms are putting out that they're wanting to do class action. That may be cheaper, but they still do want some money for that.
Right.
So you have to put in around $1,000 for retainer, and then they come back every so often looking for some more money.
Chaba already has a criminal lawyer, though.
Who has a criminal lawyer?
Chaba Sizzi. Am I saying it right? I don't know. So he was a trucker in Ottawa, and he got beat like crazy.
Yeah.
And he's on his third criminal defense lawyer now, slated for trial in September, and the hope to file a civil claim for damages from the beating that he took. And they're just
September. They only have 30 months to prosecute, so September's over 30 months. I think August is 30 months.
There's two issues here that I would like to add to that. Under the criminal code, there's no statute of limitations if it's a criminal charge, but there's two ways to do about it under Section 11. There can be a civil charge, they can be found guilty in civil matter, or they can be found guilty criminally. But to my knowledge, there is no statute of limitations on a criminal code. When there's a crime, if there's any additional information, that crime is still under investigation or pending. But they still can go ahead with a civil action.
Okay. Well, maybe I can set you guys up with the fellow who's helping him. Yeah, go ahead.
Yeah, Patti. You might know a little bit more about this, Patti, but there's two different ways. They can either be charged summarily or indictable. And from what I read, maybe I'm wrong, but there is a limit if it's a summary offense, but if it's indictable, then there isn't a limit. Am I correct in that? Or?
No, there's a limit. There's a limit.
There's a limit still on
it's
indictable?
A different limit. It's 18 months on summary and 30 months on indictable. That's not to lay the charge. I think that's what Patty's getting confused about. The charge has already been laid. Once the charge has been laid, they have a deadline to complete their prosecution.
I don't think they've made any charges yet at all.
What?
It's all been. I don't think they've made any charges yet. They're just planning because he's been defending himself, but they want to file a civil claim.
For what is he defending himself for?
The charges of I don't know. I need Paul. Paul, are you around to fill in some blanks?
If there's a criminal charge, like when I went to police headquarters in Toronto to lay, because I charged 2 police officers, and I had to go make a video statement at headquarters. They were on the outside, they were mirrored. They were on the other side. But when I was giving my statement, I was told that any additional information when it's criminal charge and it's continuous investigation, they can still be held accountable criminally, but also that the chief of police do have the authority to charge their officer, as well as their deputy police do have the right to charge their officer. I had filed a complaint with Oprah.
Patti, I think they were asking about the civil action in conjunction with the charges, related to the charges, because he was beaten up. And it's apples and oranges is what I'm trying to say.
Yeah.
But I'm trying to give advice that he may be able to get his charges dropped because they're taking too long to prosecute him.
Right.
And
Right on.
what you're talking about is the length of time they have to lay a charge. But it looks like he's already got a charge because he's defending himself with 3 different lawyers.
Exactly.
He must have already been charged. But
I
he's
understood
considering
charging the police because you still have that option. When there is blood,
you do have that option.
You still have the option to charge the police.
But at this point, his better option would be to file a lawsuit because he's only got till February 14th.
Yeah.
to file the lawsuit, but there's probably not a statute of limitations to file the criminal charge, as you're saying.
As your civil, yes, they have till the February 14th. This is where that sections 11 comes in, whether it be civil or criminal. You could still pursue the civil and then later on pursue the criminal. So that he could have two different actions.
Mm-hmm. Mm-hmm.
And this is what I did. I went both because I feel for the injuries that I sustained and scars that I've got for life. I mean, that guy ripped my arms right out of my shoulders and then later bombed my car. And I wouldn't let it go based on just the principle. They run fear into you, fear to be afraid of a police officer, whereas the police officer is there to serve and protect. And when I went to the chief of police, the chief of police, I actually had to file a complaint about him because it said, that's your officer. You are responsible for that officer. And the other officer, the deputy officer, said to me, well, these are my men. You're going to get me in trouble. I don't care. Look what they did to me. So we had to go to headquarters in Toronto. And that's where you need to go. If there's anything to deal with jurisdiction of different police in different areas, you go to headquarters. Don't mess with the middleman because they're all those team leaders. They're there to protect their own. But they're there to serve the people. And this is what a lot of people need to become or realize. Some of those officers, though, were brought in from different countries. There was foreign interference. They come in and they were sworn as peace officers, which gave them a right to come into our country when there's foreign interference and then beat up on our people.
And another thing they've been doing in the charges is not identifying the arresting officers, which is ridiculous because that's an improper way to proceed with a charge. And what they're saying is they have these pass on or pass
handoff
off
team.
Stand off. What is it? Pass
handoff
off
team.
Handoff team. So that you don't get the arresting officer's name, and that they are the ones that are hands on with you. And if there's any violence and rough play or whatever, they're the ones that need to be identified, and you don't even know who they are. So that creates, I believe, an intentional obstruction.
Well, that's where you would use occupier's liability because those police officers, whomever dispatched those officers, are still responsible under the Occupier's Liability Act. So this is what I did. I applied it because those officers, I don't know who the guy was. He took me from behind. So I'm not able to identify him by name, but I know what he looks like. I never forget a face. So when I went to the police headquarters, that's what I did. I applied occupier's liability. Those are your officers. You are responsible for those officers. If you won't give me his name, then I'm going to hold you responsible under the Occupier's Liability Act.
Excellent. Well done. Very good. So let's talk about solutions and that taxpayers should not have to pay for an appeal that wouldn't be successful anyway. How's that for a loaded question?
Mm-hmm.
Yeah.
But primarily not because if it's going to be successful or not, but because these individuals have been deemed to have acted outside the law. Mm-hmm. So there should be no indemnity. So and that's ruled. It's not like we have a system that says, oh well, it's just tentative because it isn't at the top level. It's the firm decision already. Mm-hmm. And if they don't like that decision, they should have to act from their personal position and appeal it with their own money. If they win, well, okay, then the official decision has changed and they can be paid back. But in the meantime, they've been ruled and judged as being outside their official authority, meaning that they're personally responsible. So they should be responsible for appealing of that.
And is there a petition already out there, or are you developing
one
right
that
now?
is going? I'll let Janice tell you where it's at, what we've done with it, where it's at. Maybe even read it if you can bring it up. If not, I can bring it up.
And if there's a link, please send it in the private chat here.
Yeah. So we don't currently have a link up yet. So what happens is when you have a petition, you're supposed to have an MP not endorse it, but like approve it, I guess. So
Sponsor it.
Yeah, thank you. To sponsor it. So Larry Brock and Glenn Motz have both been very vocal about all the grounds that the Emergencies Act was illegal. They're also both part of the Special Joint Committee on the Declaration of the Emergencies Act. And so Larry Brock, he is the MP of Brantford area. And so I really wanted to get Larry Brock to sponsor it. So I called their office and I was told that because I'm not in Brantford, I should call my own MP. I'm like, well, our MP is horrible. So we found somebody who, Jim, what was her name again? She's going to be presenting it.
Mandy Steering.
Yeah. Yeah, so Mandy dropped it off at their office, and Larry's going to take a look at it tomorrow. And so we're hoping that he will agree to it. And then if he does agree to sponsor the petition, then we'll post it up online, we'll share it out and get that out there. I think this is the final version. I can read it out to you guys. Hopefully I have the correct final version because we went over it and edited a number of times. So I think this is the final one. So it says, whereas in a decision of the federal court released on the 23rd of January, 2024, Justice Mosley ruled that the invocation of the Emergencies Act on February 14, 2022 by Prime Minister Justin Trudeau was unjustified and unreasonable. 1. The required conditions for proclaiming a public order emergency stated in Section 3 of the Act did not exist. 2. The procedure for invoking the Act, as stated in Sections 17 and 25 of the Act, was not followed. 3. Using the Act to quell a peaceful and legal protest against the government's COVID mandates was illegal. Prime Minister Justin Trudeau acted outside his legal authority by invoking the Act and therefore has no legal protection against prosecution for damages caused by applying the Act. And then we list 3 different case laws that support that. I say Chrystia Freeland has stated that the decisions will be appealed. Therefore, we, the citizens and residents of Canada, ask Parliament to withhold any public monies for the appeal by Justin Trudeau, Chrystia Freeland, and others.
I have a link. I can send them a Google link.
Perfect.
Okay. I'll send it to Beth.
There's also.
Can I talk about what I'm doing?
Yes, please.
Oh, okay. 3 things I'd like to mention. When I filed against Trudeau in 2019, one of the things that I put in my prosecution was Section 337 of the Criminal Code of Canada. And that is a public official withholding something from withholding a thing from a person who is entitled to it and demands it. So that could be information or money, whatever. And that's one of the things I charged him with. Well, a month or so later, that's withdrawn from the criminal code. It's no longer in the criminal code. They took it out in an omnibus bill. The same bill that says, oh, witchcraft is no longer a hanging offense, tuning up the code. But they threw that in there, and it's no longer in the code. So what I'm going to be doing is reopening my 2019 case, which has a file number, transcript, and I'm going to say I've got new information that I didn't have in 2019, and this case should go forward. And that's how Jane's going to help me, and I'm going to say now we have information that Trudeau has committed treason, high treason. So that's what's going to be going forward as soon as possible. And then the plan is, if this goes forward, and it should, because it's already in existence, it's not a new action, then everyone can act as an intervener in the case because it affects all Canadians. And that would basically turn it into a class action suit. Wow. And the third thing I'd like to mention is if you go on Google, not DuckDuckGo, but Google, go on Google and type in my name. The first link that comes up is the Intellectual Property Office of the government of Canada. And if you click on that link, it shows that I own around 30 different laws. The government of Canada has sold me the Bill of Rights, the Charter of Rights, and the Criminal Code for $50 a piece.
Okay, it's not high treason, it's just treason, just to clarify.
I thought it would be high if you brought in foreign troops.
No.
Okay, doesn't matter.
It's a higher level. Like it probably is close to that, but we just have to have evidence for treason. I would rather just, it's life imprisonment for treason anyway.
Yeah.
So it's all good.
Oh, whatever works.
Yeah.
So yeah, the government has sold me a number of laws.
So, Norm, I'm wondering, what was the document that the public official was withholding? Like, which documents are you referring to?
I wasn't referring to.
Okay.
It was to do with the SNC Lavalin.
Right. Okay.
All right. Well, this has been
treason,
fantastic.
The treason is under 46(2)
46(2)(a)
Criminal Code, and it says everyone commits treason who in Canada uses force or violence for the purpose of overthrowing the government of Canada or province. And you see, if they got away with what they're doing, that would give them ultimate authority, and they can exercise that authority under direction of foreign bodies, which they were doing. They're even doing it in our face. And actually, I was going to talk about just quickly another Supreme Court decision.
Can I clarify one thing, Jane?
Sure.
There's something that really confuses people a lot of times when they hear the definition of treason. Everyone commits treason who in Canada uses force or violence for the purpose of overthrowing the government of Canada. They go, well, how can the government of Canada overthrow the government? And that kind of confused me at first too. So I did some digging, and it says overthrowing the government is defined as typically it is an illegal, unconstitutional seizure of power by a political faction, military, or dictator. So, which is exactly what he did. It was illegal. It was unconstitutional. He seized power into his own hands by ignoring the parliamentary process, which is what we're showing in the criminal incident report. So,
Fantastic.
And you see many items of evidence to show that they're following the directives of the World Economic Forum and the World Health Organization. And one ruling that I'm also very optimistic about, Supreme Court decision on October 13th, 2023, where the Supreme Court overturned a federal law that prohibited Alberta from selling gas or oil to anywhere in Canada. Now, where that came from is an agreement that Canada signed with the UN in 2019, giving them authority to direct the use of our natural resources. And one of the first directives was that Alberta is not to sell any of their oil and gas to anywhere else in Canada. So the federal government put a stop to a pipeline that was planned from Alberta to Quebec. They just stopped it and then passed this law confirming these directives, or enacting these directives. But our Supreme Court said no, federal government had no authority to pass such a law as that. So that gives me great hope, because if these international agreements had any authority within our legal system, then that would have trumped everything. That would have trumped, the agreement itself would have trumped. And that's what they're trying to tell you with the takeovers of the city halls, with the 15-minute cities and all that shit. They're trying to say, oh, well, Canada signed this 2021 agreement and the 2030 agreement, which gave the UN the authority to restructure, and even the free trade agreements theoretically gave them some authority to restructure Canada, basically. And the way they wanted to restructure the city is to get rid of our city hall and put in an international board with even private. So it's private public board that's going to rule us with no input and no, it's like our rights are out the window because they're trying to act as though all our Constitution, all our Bill of Rights, all our common law has no validity, and that's bullshit. And the Supreme Court is confirming that. And there was another one in 2022 that was initiated by a professor of law by the name of Ryan Alford, and he brought a constitutional challenge of a law that the Liberals were trying to pass to eliminate parliamentary privilege, because they want to get that out of there because it gives them more free reign.
Alrighty. Well, thank you so much, everyone. Oh, how did that happen? Thank you so much, everyone, for joining us today. I think we just lost maybe Jane by accident. You
Okay,
removed yourself.
I'm back. Oh, I didn't
There
even
you are.
touch anything. I didn't touch anything.
Yeah, that was weird. I was,
Yeah.
yeah. Anyway, I'm just
Yeah.
trying to help somebody on Facebook.
Anyway,
Who
that
can't get the sound, but
2022
it's okay.
agreement was also a Supreme Court decision. And what he argued was they can't use legislation to override common law rights. Okay, because that was in common law. This parliamentary privilege was in common law. And the parliamentary privilege, one element of it is where they can say whatever they think whatever they think the public should know. They can speak. They can't be muzzled on any topic, even national security, blah blah blah. They can say whatever they want without any reprisal from anybody. You can't sue them for anything they say in the House, and the government can't sanctions on them for anything they say in the House. They were trying to get rid of that, and Alford argued no, because you can't use legislation to override common law. So that principle can be applied to every freaking thing that they're bringing in that overrides our rights. Every single thing. It's the same principle.
Mm-hmm. Very good. Great point.
Yeah.
It's amazing. So I apologize. I'm starting to be out of time now for the subject that we've got. If there's more updates, I'm happy to share with my people on a variety of platforms. This did go live to Facebook. Most people could hear it over there, but I also shared Rumble. Rumble had a fantastic turnout, by the way. Thank you so much for being over there. It's a brand new channel, and I really we can't see it now. We're all decentralized, which that's fine. That's safer from censorship in general. Thanks to everyone who joined on Rockfin and my new YouTube as well. So that's much appreciated. Thank you, everyone, for your work, for your tenacity, as I mentioned, for not giving up, for taking this now what is a win, and helping the people move forward in probably what will be a much more powerful way given this evidence.
Mm-hmm.
I'm assuming it's a good time for others to come forward, depending on the statute of limitations and the timing of whatever it was that happened to them. What's the best link to share out, Jane? Is it your website, which is?
There's one I gave you a link for. I think I saw it in your list. Sue.
It's in the notes.
No.
I apologize. Let me see if I can grab it. I've got a bit of a weird. Oops.
I can send it again.
Yeah, if you can drop it in the private chat right now, or let me see if YouTube will give it to me. I had some glitches, let's say, and they don't give you the notes.
Beth, just to mention also, the Canadian Constitution Foundation on their webpage had put out also a petition, and it was petition to Trudeau to not appeal Justice Mosley's decision. So if anybody wants to reach out to their page, it is on their page as well.
Here, I send it to your phone.
Okay, I grabbed it. Thank you. Sorry, put you through that as well. So yeah, trudeaufortreason.com/Sue-Trudeau. That's music to a lot of people's ears. You wouldn't believe it.
And they can show up to our meetings on Wednesday at 8:00 on Zoom.
Wednesday at 8:00. Okay.
Yeah, if they want to sort of get ongoing feedback as their claim proceeds. We're not taking on the case per se, but I can be available for consultation for anybody that's wanting to file this for self-representation, and it's only $108 to file, and you can have that waived if you're on low income. It's called a fee waiver. You ask the court for a fee waiver, so then it's zero, and then zero legal fees because self-representation.
Amazing. Very
Yeah.
good.
Janice, how much is your legal bill for your charges with the convoy?
0.
Yay. I'm so
Join person as well.
just
Yeah.
a little sweat
She was
equity.
charged with the Coots boys, and she got her charges dropped.
One thing people got to realize too, if you're in those court cases and you're self-represented, you're before the courts, whether it be in civil or in small claims, you have the right to request costs because your time is just as much
That's right.
valuable as anybody else's time. And I actually, I had won in my civil case. I won in my case, plus I won costs. And there's a case study in Canada. It's actually, ironically, Justice Rouleau's case law to say.
I have literally one more minute. I'm so sorry, Patti. I don't have time for another story for the way I'm scheduled right now. But if there's something that you want me to share, I will pass that on. Or if there's a link to anything that you want me to share right now, then I'm happy to do that as well. So I apologize.
No problem.
Yeah, it'll stress me out if I go any longer. But I love you guys. I'm so happy you're doing what you're doing. Go team. That God comes through you and tells you to do these things, just like God comes through me and tells me to do my things. And I want to make sure and let people know that I am speaking at Anarchapulco, I think it's 1 week today. Yeah, one week to February 11th is the actual talk. And I'm giving a talk and 2 workshops, one of them on the archetypes of controlled op, which I know, Jane, you're very into. Yeah, exactly.
Well, one of the new ones is they're not talking about this federal court decision.
Right.
Because that would blow their narrative that we have no justice, and we have no good laws, and we have no good politicians, and no good judges, and no good police officers. That kind of blows that out of the water. And it's not just that. There's many, many other, like Dave can tell you some really positive stories about some really good judges that we have. There's bad ones too. And I'm not taking away from the devastation that a bad judge can cause. But there's some really good ones, and we're not done yet. And we're not gonna give up, and we're not gonna lose.
For sure. So really quickly, I want to let people know that I actually do have a list of 32 signs of controlled op. These are not the archetypes, by the way. That's a different project that I'm still working on. Maybe, Jane, I'll have you on specifically to talk archetypes, because when you learn the patterns of something, you become less vulnerable to every little shiny object or guru or person that says they know everything. Then you can start to have more discrimination for yourself. If you would like to receive my list of 32 signs of controlled op, then you can email me, beth@bethmartins.com, or you can jump on my Facebook or X or anywhere. I need your email to send it because I'm not publishing it publicly. It's a work in progress right now. So it's only for people who are already in my world. And so I think that's all for now. Thank you so much, everyone, for joining us today. It was fantastic. Jane, Janice, Patti, Norman.
#we got this.
All right.
Thank you.
Okay. Thanks, everyone,
Thank you.
for coming.
Bye.
All right. Bye for now.